Good afternoon. I'm Paul Schrader from with the Chess Student Advisory Council, and today I have the pleasure of excited to introduce Jason Hernandez, Director of Rutgers Immigrant Community Assistance Project. Jason is a 2011 graduate of Temple University's Beasley School of Law. He joined Rutgers Law School in August 2017, hired as an immigrant rights attorney to found the Rutgers Immigrant Community Assistance Project, RICAP, and RICAP offers free legal consultations and individual representation to Rutgers students and provides community immigration and know your rights presentations throughout New Jersey. Prior to that, Jason was a director of the Asylum Outreach Project at SIJS, Pennsylvania, a refugee resettlement and immigration legal services nonprofit organization in Philadelphia. He also served as a co-chair of the Pro Bono Committee of Philadelphia chapter of American Immigration Lawyers Association, connecting Delaware Valley residents to free legal services. He received his BA in philosophy with a minor of anthropology from the College of the Holy Cross and participated in a year of service with the Jesuit Volunteer Corps prior to moving to Philadelphia in 2008. Please join me as a representative of Chess Student Advisory Council, along with the Office of Social Justice, Inclusion, and Conflict Resolution, in welcoming our guest speaker, Jason Hernandez.
Should I use this mic? Yeah, maybe. We'll see. Well, thank you so much for that wonderful introduction. Thank you, Dean Fleming, for the invitation today in the Social Justice Office. It's really a pleasure to be here. Definitely, this has been a really timely topic. Throughout the past academic year, I've been working across the 3 campuses of Rutgers University in Camden, New Brunswick, and Newark, meeting with students to advise them of different avenues to pursue immigration benefits and relief under the Immigration and Nationality Act. Additionally, I've been traveling around the state giving presentations to different universities, community organizations, school districts, to basically help individuals get informed about immigration issues and the landscape that's facing the United States today. I think we've heard a lot about immigration in the news over the past 2 years, and probably well beyond that, actually. And a lot of people have fairly strong opinions, but I think there's not actually that much knowledge out there that people have to say specifically why they're pro immigration or immigration reform, or why they oppose immigration. So my goal today is basically to cover sort of a brief history of what immigration has looked like in the United States since it began, but more importantly, sort of what we're faced with now as a nation in terms of current immigration law and policy. Finally, I'll talk a little bit about dreamers in the United States, deferred action for childhood arrivals, and sort of what comes next, touching a little bit on advocacy in that regard. So the information that I'm going to discuss today is basically good today, right? There have been a lot of changes. Even this morning, the Supreme Court came out with a decision on a preliminary matter in the District of California case, which we'll talk about in a little bit. And so really this information is good up to this minute, but who knows what will happen tomorrow, who knows what will happen next week. Many of us are waiting to see what will happen in the Circuit Court of Appeals of the Ninth Circuit in terms of what will happen to the DACA rescission injunction. So just keep that in mind as we proceed. So again, this is just a quick roadmap of what we'll be talking about today. And so we'll start by just sort of talking about immigration past and present. There are just a couple of items on a timeline that I'd like to go through, primarily because I think they paint a picture of sort of how immigration policy was formed in the United States. It's not the kind of policy that was thought of proactively, over great debate. In a lot of cases, immigration law and policy was cobbled together, right? A patchwork quilt, sort of as issues faced the United States, the legislator or the president would determine sort of how to interact with that series of events that was transpiring in the United States. So the first actual statute that appeared in the United States regarding naturalization or the right to have citizenship in the United States actually happened in 1790, right? So this is years after the United States became a nation. And basically, individuals who could become citizens in the United States, have the power to vote and shape the land in which they live, were free white individuals of good moral character who had been in the United States for 2 years. So very basic requirements back then. I should say that the Alien Friends and Alien Enemies Act was sort of created after this concept of espionage was introduced for the first time after we had become a nation. And so there were these concepts of deportation and detaining individuals that were also introduced at that point. But really there wasn't, just bear in mind, we have these concepts on the books, but there were no enforcers of these, right? So it was just if someone came across the federal government and was realized to have been stealing government secrets. So nearly the greater part of a century passes before we have our next major law, and this is after the Civil War. And basically at this point, naturalization is now extended to individuals who are originally from the African continent or descendants of individuals from the African continent. So now we have white individuals who can become naturalized and black African individuals who can become naturalized in the United States. The next point in history that's really important to think about is that we have the Transcontinental Railroad being formed in the 1860s. And this is the first sort of train that travels across the United States. Many Chinese immigrants were hired and brought to the United States to build this railroad. But then after the railroad was completed, the United States was not too keen on the prospect of these individuals remaining in the United States. And so to curtail immigration of Chinese immigrants at this time, the Chinese Exclusion Act was introduced and passed in 1882, which basically banned any additional Chinese individuals from immigrating to the United States. And this would actually be the first of a long line of immigration bans that prohibited individuals from Asia from entering the United States. So I'm going to go through a couple of these pretty quickly just because this is more just to paint a background picture. So the Act to Encourage Immigration also came about after the Civil War. And this was because in the absence of slavery in the United States, individuals were needed to basically work factory jobs, labor jobs. And so this created enforceable contracts for individuals who were basically brought to the United States specifically to work in sort of production industries. So 1917, we see a broad introduction of a ban on individuals from Asian countries to the United States. So if you're from Asia, with the exception of the Philippines, which was at the time colonized by the United States, you were not eligible to come to the United States as an immigrant. And also there was an introduction of a reading requirement. So you had to read in whatever was your native language, you had to read. So obviously for individuals who came from places that did not have written language, this was a prohibition as well. The Emergency Quota Act was basically introduced to basically, so the Emergency Quota Act basically said that 3% of individuals, so if you have a foreign population living in the United States, let's say members from the United Kingdom, the total number in the census of those individuals, 3% of that number was permitted to enter the United States. And so what this served in effect to do was to solidify those populations in the United States that were the majority could have immigration from the largest populations that were already residing in the United States. So this basically promoted Western European migration and created lower numbers for populations that already had lower representations in the United States. And then the Labor Appropriations Act basically created for the first time an enforcement agency. So it wasn't until 1924 that we actually had some organization or enforcement agency on the books that was specifically hired for purposes of enforcing immigration laws. Okay, so I'll just pull up the next ones quickly. Part of the reason why this is also important is because while we had these laws on the books, a lot of them governed who could become eligible for citizenship. And so even though individuals were arriving in the United States, there was no real enforcement against those individuals. And what they were experiencing was maybe lack of access to citizenship. But after the Civil War and under the 14th Amendment, birthright citizenship was created. So eventually all of these populations through progeny or having children were able to create enclaves in the United States where they did have voting blocks and power in the United States. But many populations did not actually have access to citizenship until much later in the United States history. And so we're just going to skip down at this point to the Bracero Agreement of 1942. This was during the Second World War, where basically, again, we needed workers. And so this is a circumstance where individuals were permitted to temporarily work from Mexico in the United States. No permanent residency or citizenship was extended to them, but there was a temporary time in which individuals from Mexico were allowed to cross the border legally, pursue employment, and then the reality is they built families and their children became United States citizens, right, when they were being born in the United States. So this is one of the early times where we see sort of this disconnect where individuals who do not have lawful status at some point, right, because eventually the Bracero Agreement expires, have children who are US citizens, but then they themselves cannot access many of the benefits of the immigration and nationality law to obtain permanent residence or citizenship in the United States. So in 1952 is where we get the law we more or less have today. There are still changes, but 1952 is where the Immigration and Nationality Act is introduced. And so this is more or less the same code that we have today, and it takes all the laws before this and combines them into one code. And basically reduces, again, the population of individuals who can immigrate to the United States. And this is where we have, for the first time, employment-based visas created and family reunification created. So this is what we now know as employment immigration and family preference immigration. And so this is basically the largest these two components are the largest sort of pieces of the immigration puzzle. By and large, family preference easily composes well over half of immigration to the United States, followed by employment immigration. But we'll talk about that more in a little bit. This is where we really start to see a turn in terms of the United States having an outward-facing immigration policy. We have the the United Nations Convention on Refugees, signed in 1951, and in 1953, we basically come up with a domestic law that permits 200,000 refugees to be admitted for permanent residence in the United States, which is much higher than what we have now. This is not necessarily annually. That conversation comes up later. But then later on in 1961, under President Kennedy, we saw that sort of social welfare supports were made available to these humanitarian immigrants as well. So there's sort of a humanitarian interest developing within the United States to be a global leader in human rights internationally. And the Hart-Celler Act is basically, the end of quota-based migration. So just to be clear, before this act, individuals could, this very well-known myth, right? Why don't individuals just get in line and immigrate legally to the United States, right? Because there's a very simple answer to that. There is no line. This is the great misconception of the United States population. The line existed before the Hart-Celler Act, right? So these were the quotas. Individuals could apply to immigrate, but only those individuals who were the first to apply within that quota year and then carried over every year, so there was a long delay, were able to actually enter the United States. So yes, there was a line. But after the Hart-Celler Act, the line was eliminated, right? This is where the United States shifts its policy and says, our priorities are to provide employment-based visas in the United States and to reunite families of immigrants who have immigrated to the United States up to this point and have status here. Additionally, we also know that the refugee and sort of humanitarian area of immigration law is burgeoning at this time as well. So there is no line. And then we see, this continued sort of interest in humanitarian-related policy. So I'm just going to pull out a few particular notes of importance here. So the Immigration Reform and Control Act of 1986, which is the third one down here, is particularly important because this was passed under President Reagan. And what's particularly notable about this is that this allowed individuals who were present in the United States on or before 1982, or who worked in certain agricultural employment to receive this like word that we have now coined in a very negative way as amnesty, right? So this was the first great amnesty in the United States, which was passed actually under a Republican president, right? And the idea here was that we needed to fill employment roles in the United States. We were pro family reunification, and actually as part of this, we basically protected, in addition to the individuals who were in those industries who had been here, their family members as well, so their children and their spouses. The trade-off here was that the mentality of the United States was, we will just like wipe the slate clean, grant immigration status to those who are here, who are contributing to the United States. At this point, we did have a few different sort of inadmissibility grounds, so it wasn't just that anybody could obtain status, but as long as you were not a criminal or met certain inadmissibility requirements, you could apply for status under this act. But the trade-off was that this is where we see sort of the creation of border protection in the sense of like fences. We see an increase in enforcement. Employers are now subject to raids by immigration enforcement officers who can deport individuals who are found to be working without documentation in the United States. So the flip side is we're going to increase enforcement during this time. In 1996, well, I'll just point out the Immigration Act of 1990 is also where we formalized temporary protected status. I don't cover this later too deeply, so I just want to highlight that temporary protective status is a temporary status that's provided by the executive in the United States when there are issues of armed conflict, if there are environmental circumstances. Asylum and refugee law and policy don't cover environmental catastrophe and in some cases conflict. And so this is a forum to provide some humanitarian relief internationally without having an act of Congress. This does not provide permanent residency. This does not provide access to public benefits. This does not provide any path to citizenship in the United States. But what we have seen is that individuals have had temporary protected status for nearly, for several decades at this point. And so they've built families here, they have children in the United States. So no matter how you try to plan, there are always complicating factors in immigration, and that's that these laws pertain to people who build families, who seek employment and develop their lives based on the circumstances in which they're living. So just wanted to point that out. Some of the countries that have had their temporary protected status eliminated or wound down include Honduras, Nicaragua, El Salvador, Haiti, and so Syria has been renewed for now. But those other four that I mentioned they all have deadlines, right? They all have doomsday dates, so to speak, where their status will be eliminated and they will be subject to removal by Immigration and Customs Enforcement. So the next is 1996 is really where we start to see the hammer come down on immigration, right? So 1986 was sort of this, okay, we're gonna give everybody lawful status, but we're gonna take this harder edge on immigration and have enforcement. 1996 is where we see a large increase of inadmissibility grounds, deportability grounds. We see the bars introduced, so individuals who are in the United States without documentation or authorization who leave the United States are subject to bars from re-entering for 3 years up to 10 years, depending on how long they overstay without permission in the United States. We see that there are more worksite enforcements, and we also see increased funding to build fences along the southern border of the United States. The next three are basically post 9/11 acts that were introduced. After 9/11, we started to go digital with everything. And what's really important here is that the Homeland Security Act was passed in 2002. And this eliminated the INS. The Immigration Naturalization Service was eliminated and replaced by the Department of Homeland Security, which has 3 branches under it, which include Customs and Border Protection, Immigration and Customs Enforcement, and United States Citizenship and Immigration Services. We'll talk more about them in a little bit. And also this was where in 2006, the Secured Fence Act was passed under President Bush. I've heard him speak about this, actually. It's quite funny. They interviewed him as part of Fresh Air, I think, after Trump had really ran on this concept of the wall. And he was like, I don't understand why this is so controversial. I already passed this bill in 2006. And so the Secure Fence Act actually is a double layer fence, which if you haven't seen it, it's a serious fence, right? There are turrets that have there are spotlights moving around on it. There's a lower fence followed by a much higher mesh fence. In between that area is when many individuals are detained by Customs and Border Protection. The reason it's a fence is because there are a number of environmental concerns that pertain to that region of the United States that they don't want to block with an actual solid wall. Certain areas are really difficult to build on as well. And so they have hired Customs and Border Protection officers to patrol those regions rather than building a physical structure. So this actually funded 700 miles of fence along the southern border. It's worth noting that it's not completed because the funding has been such an enormous amount that Congress has not been able to secure funds to finish the fence for the past over 10 years. So who are the players in immigration, right? So what we've been talking about up to this point is the sovereign, right? So the United States, as a sovereign entity, does have the right to control who is welcome to the United States, right? That is not in question at this point. The people we see interacting in this capacity are DHS, which is an office under the president. So this is the Department of Homeland Security and the Department of State are two sort of cabinet, the secretaries of those are cabinet positions under the president. And they govern more or less international policy and migration to the United States. We also have immigrants, right? So immigrants are individuals who seek immigrant visas. Any foreign national who intends to remain in the United States that is currently present or somebody seeking permission to enter from abroad. So these are lawful permanent residents. Certain permanent employment immigrant visas are under this category. So investors, people who are international students or studying abroad that seek some kind of employer to sponsor them, individuals who qualify for the diversity lottery. And then we also have non-immigrant visas, which are basically people who come to visit the United States on tourism, the visa waiver program, F1 students, J1 students, individuals who are here on a temporary exchange basis, study abroad basis, temporary work. And these individuals can cross into the immigrant category, but by nature of how they've obtained their permission to enter the United States, they are not, in fact, intending immigrants, or at least not in the eyes of the government. All right, so common myth that we hear is that the United States does not screen immigrants or enforce the law sufficiently. So this actually cannot be further from the truth. Whether you come through, the refugee avenue to immigrate to the United States, family preference, business, diversity lottery, the screening is the same. Actually, the screening before all of this, the recent administration's practices was even higher for individuals individuals who are refugees and for individuals who come from countries where there are quote unquote terrorist ties. Obviously, it's hard to sort of sift through all that information, but I will say that it is quite truly a myth. Because the United States spends $18 trillion annually on enforcement, which is more than all other enforcement agencies in the United States combined. In the last 26 years, the United States has spent $187 billion on enforcement. That number has to be wrong. Yeah. Sorry, I think it's not 18 trillion. There's an extra set of zeros. $18 billion. That's a lot of dollars. So 18 billion, sorry, not 18 trillion. And then over the last 26 years, it's been 187. And obviously the wall that we've heard about, which is $25 billion, that wouldn't be in 1 year. That would be over, obviously, time. But that just gives you a sense of what that price tag looks like in relation to annual spending on immigration at this point. So who are the sort of departments that are under DHS? We have Customs and Border Protection, which roughly has 21,000 agents. These are the individuals who enforce immigration laws at ports of entry. So this is anywhere along the border, individuals at seaports, airports, and there can be random road stops up to 100 miles from the border. So if you've heard stories about people who are picked up sort of in transit while they're driving, that can happen anywhere 100 miles from the border of the United States. And within 25 miles of the United States, Customs and Border Protection can enter into structures that exist, right? Beyond that, we sort of really get into the context of Fourth Amendment's privacy rights, and it becomes a bigger sort of conflict of interests. So here's just some images of CBP, right? So that's actually a border entry point. That's one of the fences in the dual fence program, and then we see a CBP officer. So the Department of Homeland Security also has Immigration and Customs Enforcement. These are the enforcement agents that work in the interior of the United States. So these are the individuals you may have heard about in Highland Park that were arresting parents. So there were 2 fathers that were arrested after dropping their children off to school in Highland Park. These are the individuals who wait outside of schools, wait outside of courthouses, go to individuals' residences, pick up individuals that are testifying in court against criminals. So these are the people who have been in the news a lot lately in terms of creating a culture of fear within our communities that prevent immigrants from sort of participating in civil responsibilities. Obviously, they have a really critical role. The United States does have immigration laws, and they are not necessarily doing something wrong in enforcing those laws. But we do have something that we call the Sensitive Locations Memo, and there are certain places that have been deemed as inappropriate for ICE to enforce, and these include schools, hospitals, certain institutions where individuals should not be afraid to access those services. These concepts, while I wish I could say that they were born out of consideration for humans generally, really the concept behind this that created the Sensitive Locations Memo is that if you have undocumented parents with US citizen kids and that US citizen kid is really sick, we want that family to be able to bring their child to the hospital for services, right? And if they can't feel safe doing that, it creates an unsafe environment for the US citizen child. And so obviously it's a complicated issue, but this is a controversial portion of the Department of Homeland Security. Also, they are the attorneys that prosecute the cases. So if you hear of immigration court cases or removal cases, these individuals are the ones prosecuting those cases. All right, so finally we have USCIS. This is the office that issues green cards, does citizenship applications. They're non-adversarial, so this is basically the benefits office. Some individuals will seek, there'll be marriage cases here. Again, sometimes it's also somewhat controversial, but they're not the ones that are actually enforcing it against anyone. They're determining and adjudicating whether or not individuals qualify for benefits in the United States. All right, and the Department of State just works on the kind of the other end of the spectrum where individuals may file for certain family members to enter the United States, and the Department of State handles the processing abroad, right? So these are the people who are verifying, whether you are who you say you are, the family relationship exists, and conduct the interview at embassies around the globe. Again, there's no line to enter the United States. There are 4 basic ways by which someone can immigrate to the United States: family-based immigration, employment-based immigration, the diversity lottery, and then humanitarian immigration. As you can see from this chart, family-sponsored and immediate relatives are the largest portion of immigrants entering the United States. This has been true for the past about 75 years or so. All right, so we've already busted that myth. So paths to citizenship, as I said, it was in the 14th Amendment that we sort of created some additional grounds to become a US citizen. Individuals who are born here are citizens automatically. Individuals who have both or a single parent who's a US citizen may be citizens automatically. And then the 2 we're going to focus on after this are sort of deriving citizenship after birth as a permanent resident. So this is basically someone who is the child of someone. So someone who is a permanent resident, their parent becomes a citizen while they're still a child, they will automatically become a citizen with that parent in certain cases. And then finally, naturalization, which is all the individuals who fill out the application to become a citizen and have met requirements. We'll talk about how to get to that point briefly after this. Okay, so unfortunately, family preference migration or family preference categories of the INA have been recently dubbed as chain migration by conservatives in the United States. That language does not actually appear anywhere in the law. That is like a very effective marketing tool to paint a negative image of family reunification in the United States. The purpose of this slide is basically just outline who exactly qualifies for family preference immigration. So if you're a US citizen, these are the people for whom you can send for or extend status to by virtue of your being a US citizen. And this includes your spouse, this includes same-sex marriage, male-female marriage. After the rescinding of DOMA, the federal government recognizes same-sex marriage under this in all federal practice. This includes children who are under the age of 21, and this includes parents if you yourself as the petitioner are over the age of 21. And then you can also, as a citizen, petition for these individuals. So this is family preference. So the first category of immediate relative is immediately eligible to enter the United States. They don't have to wait for a visa to become available. Under the family preference category, unmarried children or married children have to wait 8 and 11 years, more or less, respectively. And siblings, even if their case is petitioned, wait roughly 14 and a half years to actually enter the United States. So it's not a quick process. This is sort of something that you file and you're like, maybe you'll still want to come in 10 years or in 15 years. We'll see. But we'll just get you in line, so to speak, in this particular category. But it's not a quick process. People with green cards, lawful permanent residents, also can petition for people, but they have to wait about 1.5 years to be reunited with their family if they're a spouse or a child under 21. If it's a child over 21, they need to wait for 7.5 to 8 years for their reunification with their child. And if that child gets married, they can't come. All right, the next categories are going to be humanitarian forms of immigration relief. So we've heard a lot about refugees. These are individuals who are outside of their country and are fleeing because of persecution, war, or violence. They have to have a well-founded fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. And so as you can see, this does not include sorts of environmental catastrophe and different things like that. So there's a very specific basis by which people can enter. And this status is granted by the United Nations High Commission on Refugees, and there's a multi-tier process where they're vetted by the UN, and then the International Office of Migration, and then the Department of State, and our enforcement agencies, the FBI, the CIA, DHS, before they can actually enter the United States. Asylum is a very similar category, but it's only available to individuals who are physically present in the United States. So an interesting point that I'll make at this point is that we have this very hot debate right now about immigration in the United States and why don't individuals apply for status before they come or wait in line. We know the line doesn't exist the way that many people think about it. But additionally, what I'll say is for all humanitarian forms of immigration relief, with the exception of refugee status, you have to physically be present in the United States to apply or to qualify, right? So it is very inconsistent to say that we expect people to get in line or to apply from outside the United States, but then make humanitarian forms of immigration relief only available from within the United States, right? If that doesn't encourage individuals to try their luck and come to the United States, I don't know what does, right? Many individuals are fleeing desperate situations. And so they can either not have any options to immigrate to the US, or they can come to the United States and have a handful of options to obtain lawful status. In that situation, I think it's a pretty clear decision to make, right? Like I'll try my luck and put myself in a box or a bucket, so to speak, where I actually have a chance to obtain some kind of immigration status. So asylum, it's the very same basis as refugee status, but you have to be physically present in the United States to apply for it. Again, it's based on race, religion, nationality, political opinion, and membership in a particular social group. If you're able to succeed, which is a very rigorous standard, also a lot of times it's hard to find evidence of your asylum because persecutors do not necessarily say like, hey, we're persecuting people in our home country. Here's information about how we're doing that. It's hard to obtain that information. A lot of it is based on the credibility of the candidate. And so depending on where you live in the United States, the odds of success on a case like this are very different. And so somebody who is able to obtain asylum status is on a path to citizenship. After 1 year, they can apply for a green card, and they are eligible for a variety of public benefits. So we'll see, permanent residents who get their status through family preference are barred from any sort of immigration benefit for 5 years. Sorry, not immigration benefit. Any form of public benefit for 5 years, right? So that means they can't access food stamps, Medicaid, different kinds of public supports. And that's part of the sponsorship application. In these humanitarian categories, we do allow people to access these benefits because in most cases they come with nothing, right? Or they come with a savings that is spent, unfortunately, on an immigration lawyer or some private practitioner that charges a couple of $1,000s to represent them in their case. The U visa is a visa that eventually leads to permanent residence and a path to citizenship that is available to victims of a serious or violent crime that occurs in the United States. They have to suffer physical or mental abuse. But what's really important, and as a prerequisite, is that they cooperate or are willing to cooperate with the investigating authority. And they must get a certification from the police or from the court saying that they did this. This was basically created in 1990 because in immigrant enclaves or lower income communities, there was a rise in crime rates because individuals who were committing crimes were never having those crimes reported because immigrants were afraid to report those crimes, were afraid to go and testify. And so we saw that it was an unsafe situation, not only for immigrant communities, but all the United States citizens who live in those diverse communities. And so the U visa was created as a protection to encourage immigrants who were victims of crime to call out and report their offenders and to go and testify against them. And so why I mention that is because, one, that's what the U visa is, but also with the current dynamics of immigration and custom enforcement, then arresting individuals who appear at court to testify, it goes against the very basis of the U visa's intent. And so we've seen that it's now sort of eroded the good faith that was developed with the immigrant community in creating this U visa, because while a U visa is available to these individuals, it takes a long time to secure, well over a year. And the visa is actually not, there's a backlog that's about 8 years to get one. So they still will have to deal with any sort of negative consequence of ICE coming to detain them, go to immigration court, inform the judge that they have applied for this U visa, and then that court case will just sort of drag on or be administratively closed while the U visa continues. But it still creates a huge problem in their everyday life, right? Like, nobody wants to go to detention or go to immigration court if they can avoid it. So they just choose not to go and report the crime, right? Special immigrant juvenile status was in the news a lot in the past 5 years, especially 2012 and 13. And this is all of the young folks who are fleeing gang recruitment in the Northern Triangle, right? So Guatemala, Honduras, El Salvador, and also in various parts of Latin America. These individuals, in many cases, come to the United States riding on the backs of trains, going through really dangerous territories in Mexico and other Latin American countries. There's a lot of cross-section here between trafficking and these young people. So these individuals have to be under 21 to qualify, present in the United States, suffer abuse at the hands of one or both of their parents, which can come in the form of abuse, abandonment, or neglect. In many cases, it's neglect because parents can't afford to provide food, support their children. They tell them to leave. They basically kick their children out of the house because they know if they stay. At the age of 5 and 4, we're seeing young people recruited by Mara Salvatrucha and various gangs. And so, I mean, you have a 4-year-old kid or a 5-year-old kid, your options are to keep them with you and they'll be recruited into a gang and be holding a gun by the age of 7, or you can send them to some other country in hopes that someone will offer them sanctuary and a chance at a better life. So this is sort of the background for these individuals. And they need to be able to show that it's not in their best interest to return to their home country. This is a two-step process. You have to get this sort of finding of abandonment, abuse, and neglect from a local family court. And then after you've been able to get that, you have to then go to USCIS and file for SIJ. Again, a very long process. There are backlogs of about 3 years in certain countries. And the processing time is probably up over a year for any young person. Also, I will point out, these are children. They have a hard time at the age of 5 or 6 presenting their case to an immigration judge. There is no right to counsel. I say that half joking, but I mean, really, like, these are people who are 5, 6, 7 years old, 12 years old, who are expected to understand immigration laws and defend themselves before a lawyer in immigration court who's basically trying to prove that they don't have a right to be here. Those are not balanced scales. There is no right to counsel in civil practice, right? I mean, you have a right, but you don't have a right to one that's paid for by the government. And so we've seen a great lack of availability of attorneys because there are only so many nonprofit organizations or attorneys willing to do this work for very little pay. So even though this benefit's available, unfortunately, many children don't access it. We also know that the Violence Against Women Act was passed in 2001. Yeah, 2001. Oh, 1994, sorry. 1994. Let me correct myself. The U visa is actually 2001, and the VAWA is 1994. This touches many various areas of life in the United States. How it pertains to immigrants is basically anybody who fit into a family preference category, who then is a victim of domestic violence, can remove themselves from their perpetrator of that violence through this act without fear of deportation. And so what we had seen before was that individuals who were subject to domestic violence or threats by their spouse, you know, if, like, they would beat them up or do something horrendous to them and say, if you say anything or you report me to the cops, I'll have you deported, or I won't show up at your visa interview, or I won't do this. And so this was a way to allow individuals to separate themselves from their abuser without jeopardizing their ability to remain in the United States or with their children that they've created with their partner in the United States, so that individuals would not feel required to remain with their abuser to avoid deportation and separation from their children. The T visa is basically a visa for individuals who are trafficked to the United States. That's individuals who are brought here forcibly or under false pretenses, basically saying that they were, you know, we have a job for you here in the United States, like, come with me. And then when that person arrives, you know, they're held under lock and key and forced into sex work or forced into some kind of forced labor. Unfortunately, a lot of the children I referred to in the SIJ slide are abducted on their journey to the United States by these sorts of folks, traffickers, human traffickers, and are forced into this sort of new age slavery here in the United States and globally. So now, DACA, I'm going to talk about just really quickly what the rescission has meant. So obviously, DACA has been in the news a lot. It's an executive order that was passed in 2012 by President Obama that allowed individuals who were 16 years of age or older that had been here since June of 2007 to apply for a deferred action and work authorization. So this does not provide a path to citizenship. This does not provide access to any sort of public benefits, welfare supports, financial aid. This does not provide a path to citizenship, right? This basically just says, we will not enforce against you. We're going to defer our enforcement. So basically, you don't need to worry about ICE, and then also we'll give you permission to work. But that's it. That's what it provided to these young people. It also provided advanced parole, which was in an emergency situation. Your grandmother's really sick. You have a relative that may not live for too long. You could apply for permission to go and visit that person, but only in really specific circumstances. And obviously, many of the people who were in this program were very hesitant to use this privilege because who knows whether they would be readmitted to the United States. It's worth noting that at the ports of entry, any immigrant can be denied re-entry at any time, even with permanent residence, if there's a reason to deny that entry. All right, so the rescission was announced on September 5th. And this basically said that individuals who had expiration dates in the next 6 months had 1 month to renew their DACA status. Everybody else, you are in your final DACA term, and after that, you will be not protected, you will not have work authorization, you will be subject to removal. And the way that the administration likes to spin this is that, you know, we put it in the lap of Congress, right, and we encourage Congress to legislate. But what I'll say is on the tail end, that has really complicated things. And I'll talk about that a little more in the path forward slide. There were 3 things. So basically, come March 6th, right? We heard a lot about this deadline. What happens on March 5th, right? There's not going to be some cataclysmic event. There's not going to be like a mass descending of ICE on DACA recipients. But what will happen is that starting on March 6th, right, if this DACA rescission is allowed to be in full force, is that the first DACA recipients will lose their status because they're the first people who are not eligible to renew. And then every day for the next 2 years, the number of DACA recipients will dwindle to 0 as each day passes and another set of DACA recipients' status expires in the United States. What can stop this from happening? Well, there are court cases that have basically impacted the rescission. Congress could actually do something, maybe. And then also Trump has tweeted that if nothing is done, he will revisit the topic and he may do something about it. What that would mean is basically delaying the rescission, although that just seems unlikely because his position is that he doesn't have the authority to extend that kind of authority or power, executive power. So to do that would be antithetical. So the courts have been the first to answer the call. We've heard a lot from Congress, but nothing has actually been done. The courts, we've seen cases filed around the nation. Actually, I'll talk about them in a minute. I just want to point out, at Rutgers University, we've seen many DACA recipients have their status impacted. The university has roughly between 420 to 500 students who have this status, thanks to the New Jersey in-state tuition that was passed in 2015. You know, many students have been able to finance their own education at that in-state rate. But make no mistake, they're not receiving financial aid in most cases. With the rescission of DACA, they may lose their employment, right? So they won't be able to continue their education. This is a very serious concern. Without DACA, they won't be able to continue to have their driver's licenses. If they've purchased vehicles, those vehicles will go unused, then they have to sell them. They'll have to cancel their car insurance. Many of our students, you know, we've seen a change in what the student body is composed of. Some have children who are United States citizens for the first time. They'll experience what it is to be an adult in the United States and not have DACA protections. And so they're thinking about powers of attorney. If they lose their DACA, like who will make this, and they were detained or deported from the United States, who can make decisions about their children? And that's something that faces every undocumented parent in the United States. And then also, what will they do after graduation, right? Like we've seen, you know, DACA is not a permanent solution. So what will happen? We don't know, you know, like all this investment in education, we encourage our young people to pursue an education. That's the path to success. But then at the flip side of that, if you can't work with that education, it's very difficult to have that be your path to success. And so with all of these sorts of unknowns that have been introduced by the rescission of DACA, students are facing a lot of psychological distress. And emotional distress, where counseling is really important at the university. And obviously, you know, we hear a lot about the legal concerns, but this is impactful to students' academic success in a lot of ways. And so the courts decided in California and in Brooklyn so far that basically they were going to put a pause on the rescission of DACA. They did not determine whether the rescission of DACA was lawful or not lawful at this point. But what they said was, if we don't put a pause on this to give us time to decide, irreparable harm will happen to those individuals who benefit from DACA. And these are DACA recipients, institutions that have DACA recipients attend them, employers who have hired DACA recipients, municipalities that have hired DACA recipients into training programs. These are what the lawsuits are made of. These are all the different stakeholders who are invested in DACA recipients having employment authorization in the United States. I will say that, quick update today, the Supreme Court denied a bid by the administration to leapfrog the appeal process. So normally, the injunction that was passed back in January 9th will go to the Ninth Circuit Court of Appeals and then to the Supreme Court for ultimate decision. The Ninth Circuit may decide to affirm the decision, and we see the pause is continued. They may overturn it. What the administration was trying to do was take the decision away from the Circuit Court and just go straight to the Supreme Court. This is an extreme measure that has only been used about 5 times since 1970. So that just gives you a sense of how adamant the administration is about sort of removing DACA as an executive order. So the Supreme Court basically said they would not hear it. And so it has to go through the Circuit Court normal process, which does buy a little bit more time. So basically, the preliminary injunction's key points are that no new individuals can apply for DACA, only individuals who have enrolled in the program at some point in the past. I don't want to spend too much time on this because you're not lawyers, but basically, anybody who filed anybody whose status expired before, So if you filed your application for DACA for the first time before the rescission was announced on September 5th, you will have your case processed normally. That still will happen, but if you are trying to file after September 5th of 2017, no new application. So if you've never made yourself known to the government before, now is not the time. And anybody who had an expiration date that happened a year before the rescission can file using the renewal application, which is a much more like a simple version of the application. A really minimal amount of evidence is required because you're using a renewal. Anybody who had an expiration date before that has to file an initial application, which is a much lengthier process, much more difficult to prove. And the advanced parole that I mentioned to travel outside of the United States is no longer available and continues to be unavailable to individuals with DACA. All right, so where do we go from here? The courts are not a permanent solution by any means, so legislation is the path forward. The White House has introduced 4 sort of initiatives that they want addressed. One is the solution for Dreamers. The next is increased border security, which we have heard from the president means a border wall. And then an end to family preference immigration, which again, this is basically asking for a reduction of like what is immigration in the United States, right? We're seeing like if this is the largest portion of immigration, basically they're referring to this like it's not a big deal, but this will more or less end immigration as we know it. We don't know who will be included in this category. And then the diversity lottery, which is really only 50,000 visas annually, which is a drop in the bucket in terms of our greater immigration system. So basically, this is a very tough negotiating position for Democrats because the rescission of DACA has made this an urgent matter, but obviously now there have been many more issues introduced. And so this is more of like a comprehensive immigration reform conversation at this point. And so it has just been a really complicated sort of negotiation process in many ways because conservatives would like to negotiate an overhaul to immigration on the backs of 1.8 million young people who have been, eligible for DACA, and just like throw out the other 11 million people who might benefit for some sort of immigration status or just changes to future individuals who might apply for immigration through various systems. And so basically it takes like a very small issue and is trying to force a much larger negotiation on individuals who are made vulnerable by an act that the president made himself on September 5th. All right, so I see I have a colleague in the room, Daniela Velos from Undock, New Jersey. I just want to point out, these are some organizations that work in the state of New Jersey that do a lot of advocacy work. Make the Road New Jersey, you've probably heard a lot about. They do different advocacy events around the state. They can help you if you're interested in setting up a program here at your university to do a campaign or anything, where you might reach out to local Congress folks or senators to basically state your position on a Clean Dream Act or whatever your position is in terms of immigration reform. A Clean Dream Act is basically passing a solution for Dreamers without these other rider items. Just negotiate what's on the table. I think many advocates recognize that, best case scenario, but also very unlikely would be a Clean Dream Act. But I think the conversation in many ways should be limited to, border security and the Dreamers, right? That's really the 2 major topics that have been sort of discussed in the same context. But I mean, you know, there are people who will say they're not willing to concede border protection. At any rate, there are a couple of local initiatives in the state of New Jersey. S699 was reintroduced this year. So back in 2015, when the New Jersey DREAM Act allowed for in-state tuition, there was actually another portion that was approved for in-state aid. But Governor Christie had a conditional veto set forth that said if the in-state aid was not removed, he would veto the entire bill. So it was removed. And now, since we have a new governor in the state of New Jersey, it's been reintroduced in hopes that it will be passed through the Assembly and Senate and then ultimately signed by Governor Murphy. And this would allow for in-state aid for Dreamers who had attended high school in the state of New Jersey and graduated and attended there for 3 years. There's also a driver's license campaign because, again, driver's licenses are not available in every state to individuals depending on their immigration status. And it's important for individuals to have some form of photo ID. Undocumented folks don't have photo ID unless they get cedula or some kind of ID from their embassy. And so it creates problems picking up your children from school, when you go to the hospital, when you go to any sort of place where you have to identify who you are. Undocu Jersey, I'm going to invite Daniela up here to talk a little bit about it in a minute, basically provides advocacy and information about access to higher education for undocumented students and also K through 12 trainings. And the New Jersey Alliance is basically a collaborative of organizations that work throughout the state of New Jersey on a pro-immigrant advocacy agenda. All right, and that's pretty much all I have. But first, I just want to have Daniela come up and just speak briefly about the work that she's doing.
Good afternoon, everyone. My name is Daniela Velez, and I'm the director of Undocu Jersey. We are... Ooh, okay. We are an organization. Yes, so I am the director of Undocu Jersey. We are an organization that does professional development and advocacy work in higher education. Our goal is to make sure that throughout the state of New Jersey, professors, guidance counselors, and students and parents are aware of all the resources that are out there for the undocumented, documented, and mixed status families. In the professional development aspect, we do conferences all day for educators, K through 12, including colleges and universities. We've even done presentations for student, board of directors, K through 12, and even in colleges and universities, and explaining the different factors that come with being undocumented, having DACA and mixed status. As for college fairs, that's something also that we do. We've partnered in with Rutgers, we've partnered with local community colleges as well, in which we provide different resources, or we assist colleges in finding resources for their students. We were able to partner the Dream.us with Rutgers Newark, so we're looking to partner that again with either New Brunswick or different universities. Colleges usually come to us as well and looking for partnership opportunities or finding funding sources for these students. So basically our goal is to make sure that students have all the tools and access to higher education, and mostly getting them out there in their junior and senior year, because we've noticed that there's a lack of communication within the undocumented community, and especially now than ever, students are not coming out saying that they want to continue their education because of the new administration that we have currently. We've also working with the different organizations that were mentioned here. We do different speaking engagements, and we also assist undocumented students with filling out paperwork, FAFSA applications for mixed status students, because if they are U.S. citizen born but their parents are undocumented, there's a little different paperwork that can be filled out for them to get all the funding that they need, and that's something that a lot of students are not aware about. And also we make sure that all the students have access to the New Jersey Tuition Equality Act. We've seen a couple cases where students are eligible for it, and a lot of universities are not aware, and they've been charged out-of-state tuition instead of in-state tuition. So we work with just the different access to higher education for these students. Thank you.
You can hang out a little bit in case there are questions. All right, so at this point, I'd just like to ask if there are any questions. So the question is, why not just make, you're talking about Dreamers?
Yeah.
Yeah. So why not just make Dreamers citizens? I mean, that is such a loaded question. So there are a number of reasons, right? I mean, there are lots of reasons why I can say we should make Dreamers citizens, right? You've probably heard this through different media stories, right? These young people did not choose to come to the United States. That's also a statement that's made at the risk of demonizing the parents that did choose to come to the United States. I don't know that it's so simple just to say because someone chose to come that's a bad behavior, right? Absolutely, we have laws and those laws need to be respected. So on the flip side of that issue, I think in short answer to your question, many conservatives believe that by offering a path to citizenship to Dreamers, we encourage undocumented immigration to the United States, right? And so there have to be consequences. Now the response is obviously that, you know, their entire lives in the United States as undocumented youth have been consequences, right? So not having access to driver's license when they turned, so DACA was only introduced 6 years ago, right? It covered people who were up to the age of 31, over the age of 16. Many people were adults who couldn't have driver's license in the United States, couldn't work legally in the United States. There is no incentive to pursue academic success because there's no hope of paying for a higher level of education, right? Many scholarships, so all federal financial aid is prohibited to these students. Many scholarships have permanent residency and citizenship requirements. So I mean, it's a disincentivized structure for young people who really are faultless in their being present in the United States. I think that the question is a good one, but I think it's like something that would go on for days and days of debate, right? I think one of the greater questions is, you know, as we sort of think about what to do with Dreamers, really there has to be a bipartisan conversation about immigration reform. My point with having that like flurry of different statutes at the beginning is that we've never actually sat down and thought about how we want our immigration system to be structured, right? Like what are the quotas that we want to have for immigrants from outside, you know, intending immigrants to come to the United States? What is a reasonable amount of time for someone to wait to enter the United States? You know, right now we have very discrete categories by which people can enter, but that is not open immigration. We have a very restrictive immigration system. And the fact is, it's failing, right? It's failing for a number of reasons, right? Our humanitarian policies, while good, and if you look at it on the international scale, they're very good. But the thing is, they're not set up in a way that promotes like an orderly access to them, right? Also, I mean, just the way that family preference is set up, there are a number of ways by which someone can be waiting to enter the United States and events transpire that then prevent them from being eligible. So like a lot of DACA recipients that I've met, you know, were qualifying for family petitions, but then their relative passed away or something really tragic happened, and then they just lost their petition, basically disappears with that individual who submitted the petition for them. So there are lots of cracks in the Immigration and Nationality Act through which people fall. And I think if we really want to address sort of immigration on a larger scale, we need to sort of think about it, you know, from the ground up. The other thing I'll say is that, you know, we can increase enforcement all we want, but what that results in is more people being arrested and detained and then being sent to immigration court, but we don't have the funds in our immigration courts to actually hear these cases timely. The average wait time for a merits hearing in most parts of the United States is about 3 years. Those individuals are residing in the United States with their cases pending, and are they just supposed to not like have relationships with people or have children or try to survive? How do you survive while you're waiting to have your case heard without working? And so, I mean, there are a lot of problems that are much greater than just enforcement. Enforcement just piles up the, you know, the queue of people waiting to have their cases heard. Right, so the question is, will we see other statuses being attacked the way we've seen DACA be attacked? I think the short answer is we already have, right? So under this administration, we've seen the first attack on legal immigration, right? So the fact that, you know, we see a lobby now to end family preference, you know, that's attacking a lawful means of immigrating to the United States. One conversation is, should we do something about people who are immigrating illegally to the United States. Another question is, should we do something about people who are immigrating legally to the United States, which is, I think, what is being conflated in our current conversation. The second thing is, with the travel ban that we've seen, these are individuals who have played by all the rules, who have been recruited by universities or pursued universities, who are, quote unquote, they fit into the conservative merit-based immigrant scheme. But if you're from a Muslim majority country that has been listed on the travel ban, you're being discriminated against, right? And so we're seeing individuals who go through the same path as any other immigrant to seek an F1 or a J1, and their ability to travel home on a break, or their ability to pursue a residency, right? There have been stories there has been a lot of coverage about medical professionals who have been, passed up for residencies during match period because, places are not willing to take a risk on someone who is not able to get back into the United States after departing for a break. And so, TPS, right? We've not seen 4 conclusions to TPS in such rapid succession in our history. And so, temporary protected status is ending for many people. DACA will be ending, barring a solution for many people. Access to, re-entry for students or certain visa holders, non-immigrants, are affected by the travel ban, which has been, by the Supreme Court, it was permitted to go into full effect in October. So, the next question, whether or not we'll see enforcement against lawful permanent residents, that would require a larger change in the Immigration and Nationality Act and deportation grounds. But I will say that we've seen an increase in grounds for deportation. You get a couple of DUIs, and that's basis for deportation in some circumstances. It really depends on the situation. But I think we are seeing an attack on lawful immigration in the United States currently. Right. I hesitate to speculate. So the travel ban, I'm up to date on what it says now, but I haven't done research on the pending cases, just because my work is about serving students under the law as it is now. What I will say is that, so I don't know. I haven't read the briefs, but I will say that, the Supreme Court is currently structured in favor of conservatives, so that does not bode well. I don't know how that will work out, but I hesitate to offer a legal opinion just because I haven't actually read the briefs on those cases, and I don't want to be reckless.
I know it's a little.
Right. Well, I don't know that. I feel like the question is not so much who stands to benefit from having a broken immigration system. Maybe it's so I guess it's more of a question of why not fix the immigration system, right? Who stands to benefit from not trying to fix it? So,
or from having so many illegals around.
Right. So okay, big business, right? Loves to have workers that are afraid to pursue their rights. So I guess we could break it down a couple of ways. One is, the United States has been built on the backs of immigrants since its inception, right? So legal protections are most often pursued by those individuals who have no fear. So citizens can access justice. Even in that regard, though, the most vulnerable populations don't get the same quality of justice as those with resources, right? So if you can't afford an attorney, it's really tough. How many of you know how to vindicate your rights if you're being, abused in some way or the other? I know that I went to law school because when I worked in employment, I worked in a nonprofit that served to help, victims of, incarcerated folks who are pursuing employment for the first time after incarceration to pursue employment. And they would be discriminated against or let go from their jobs despite revealing all truthful information. And they would say, is that legal? What are my rights? And I'd be like, I don't know anybody's rights, really. We talk a lot about our rights, but really it's a privilege reserved to those who can afford to access it. So corporations can afford attorneys, absolutely. They can also afford, to pay you $7.25 an hour and not worry about the lobby for higher wages, because it's not going to be undocumented folks who are lobbying for it, right? There's a lot of fear in that community. We see a lot of wage theft down here, even in South Jersey or in parts of southeastern Pennsylvania, where individuals are not paying minimum wage. And immigrant communities are far less inclined to pursue litigation against their employers when they're not documented in the United States out of fear of what sort of retaliation will come down against them. You know, and then they need those jobs, right? So undocumented folks working in agriculture need their jobs. So, you know, what they're making might be more than what they'd be able to make in their home country, and so they're willing to take it. But the employers are really making tons off the fact that they don't need to pay a minimum wage and they can still get the same work done. In some cases, probably have harder workers. I think also, if we're going to talk about politics just a little bit, I think the broken immigration system has not been addressed in many ways because it's a really controversial topic. And so any Republican that has really been moderate towards immigration has had a really tough re-election. Cantor, for example, you know, he was moderate on immigration and he was voted out. You know, Tea Party candidates have been really successful in the wake of immigration reform, having an anti-immigrant stance or not being willing to negotiate on immigration reform. And so in some ways, you know, big business is definitely benefiting by not having a meaningful immigration system for the labor population in the United States. But beyond that, there's no incentive for half of Congress to do anything about it because it's a death knell for their base, right? Like if you come out and you're putting priorities of immigrants above, there are so many issues that need to be addressed in the United States, which I think became really apparent in the last presidential election. And so to prioritize immigrants over US citizens or to be viewed as doing that is also really complicated, right? All right, well, thank you so much for having me today. I really appreciated it. And don't hesitate to contact me. My email is available there if you have any questions after the fact, or if you just want to, you know, speak to me about my work.